Hello, listeners. Welcome to The Lawbster, the podcast for the Dalhousie Journal of Legal Studies. Here we discuss legal issues, ideas, concepts, and history. While our target audience is law students and those in the legal profession, we try not to be shellfish, so we'll attempt to present the material in a way that will be accessible to all interested listeners. Keep in mind that these podcasts are to allow people to gain insight into the law and are not to provide legal advice. Finally, we take all reasonable efforts to make sure the information is correct and up to date. However, if you have any comments, critiques, or questions, we encourage you to send them to Lawbster, that's lawbster.djls@gmail.com, or to leave a comment on our blog. My name's Dylan Wade Roskam-Zedris. I'm a 1L and Director of Podcasts for the Dalhousie Journal of Legal Studies.
My name is Jane Lawyer, and I am one of the editors-in-chief of the Dalhousie Journal of Legal Studies here at the Schulich School of Law, Dalhousie University. Now, time for The Lawbster, legal analysis in a pinch. Today we have with us Professor Michael Deterbide. Professor Deterbide is a distinguished professor at the Schulich School of Law. He specializes in business associations, business law, and law and technology.
Thank you very much for joining us.
You're most welcome.
To start us off today, Professor Deterbide, when was the last time you read a consumer agreement online?
That's a good question because a lot of what I'm about to say probably is going to be critical of what people don't do online, and I have to say that I'm just as bad as everybody else.
What comes to mind when I really think of that is people who read iTunes agreements and stuff and just click agree because, they just want to use the product that they're given. And there could be a lot of hidden terms in there. And so today you're going to be talking about the dangers of that and the protections from, legal ramifications that consumers can take.
Right. Well, not only could there be hidden terms in there, I can guarantee you probably that there are all kinds of terms in there that you don't realize that are there. And part of the problem, of course, with this relates to the internet itself and the way people interact with it. And as you mentioned, people are quick to click I agree because they want to get to the next page, or they want to get to the part of the web where you can enter your credit card number and so that you can get your widget. But if you don't look at the fine print, you're going to unfortunately, and I think unfortunately, be bound by it. And we'll talk a little bit about that and about what the courts have had to say about the small print in online agreements. But I think it's a two-part process, I think, or a two-part issue. One is the fact that there is this small print in agreements and, what the courts are saying about that. But secondly, it's also, I think, the culture of what we do online. And I can just give you a very quick statistic from a report that I wrote. That a recent study of consumer internet browsing of over 48,000 websites found that only 0.1 to 0.2% of people who visited these sites accessed online terms for at least 1 second. For 1 second. So that just gives you an indication of the importance, people have for this stuff. They can't be bothered with it. They just zip right by it and go right to the sale agreement.
So to translate that a little bit, that would be the equivalent of 1 to 2 people in 1,000 opening up their agreement for more than 1 second.
That's right.
That is quite surprising, I must say.
Yeah.
Perhaps just to back up for just a second, today we're talking about inadequate disclosure of contracts, and we kind of jumped right in there, and I love that, but just to make sure our listeners are oriented, could you just say a word or two about why proper disclosure is important when creating a contract?
Well, contracts are supposed to be about a meeting of the mind, right? You're supposed to have the two parties on a level plane, and if you're buying something, you're supposed to be fully informed, and the seller is supposed to be giving that information, and you're supposed to be giving them information about you, and particularly your credit card information or your dollars. So the whole idea, the basic premise of a contract at common law is that there's a meeting of the minds. If something is hidden and only one party knows about it and the other party doesn't, well, you don't have that sort of connection. You don't have that. Not everybody's on the same plane. So I think that's a problem, and it's particularly a problem in the consumer context because in the consumer context there is a stronger party generally, right? And if you're buying something online, for example, from Microsoft or Walmart or whatever, that's a big corporation with a lot of resources that they can use. And you are just simply a consumer, and so you are a weaker party. There's no doubt about it.
Now, in your recent article, you talk about standard form contracts and print contracts and how common law basically states that, you can have terms buried in the fine print, that there has to be bold letters and red highlighting. Why do you think this doesn't translate to the online context so
Well,
much?
I think that's a good question, and it's a question that I wish somebody would ask the judges in some of these decisions that have come out. We've got a long line of this, the so-called ticket cases that everybody learns in contract law in first year, that if there's a particular type of clause there that's going to have a particularly negative impact on one of the parties, that has to be red flagged or bolded or something to bring it to the attention of the other party. The whole notion of that seems to have just been, well, it's just not talked about in judicial decisions in relation to consumer agreements online. I'm not quite sure why that is, and it's a particular problem in Canada. There are decisions coming from courts in the United States, for example, where the courts have been willing to look at things like unconscionability, for example, for example, California has some strict consumer protection laws, and the nature of an internet transaction is oftentimes, let's say you have a California resident dealing with somebody perhaps in another state or another country, and those consumer protection laws in the other jurisdiction might not be as strong. So California courts have indicated that in those sort of situations, they're very much a proponent of the consumer and will uphold the consumer protection rights of the particular jurisdiction where the consumer resides, in this case, California. The problem with a lot of these types of agreements is that, and we can talk about some of the kinds of clauses, but one of the most nefarious is essentially a forum selection clause or choice of law clause. And you can go to almost any website, and I challenge our listeners to do this, and you read the terms of use, and you'll see probably in 99% of the cases that you are binding yourself to this contract, but that you are agreeing, well, you could be agreeing to any number of things, but you are agreeing oftentimes to waive your right to sue in the particular jurisdiction where you reside, and you agree that any dispute in relation to the contract that you're entering into will be resolved in usually the jurisdiction where the vendor resides. And that particular jurisdiction might not have, for example, strong consumer protection legislation, might not have any in some situations. There might be something, there might be an arbitration clause which requires binding arbitration. And again, you will have to travel to the jurisdiction of the vendor to engage in that. Now, who's going to do that for a matter of $100 or $500 or even $1,000 if you're going to go to travel to California to engage in arbitration? It's a big issue. I picked up the New York Times the other day, actually, and I printed off the article. And there's a major piece there. The headline is "Arbitration Everywhere: Stacking the Deck of Justice." And it talks about inserting arbitration clauses into consumer agreements. And because consumers don't read these things, they're basically contracting themselves out of their rights, right? They're contracting themselves out of the right to sue, oftentimes, particularly with respect to class actions. The vendors don't like class actions, obviously. They want their own arbitrator to decide within their own jurisdiction. And it's become a huge problem in all kinds of agreements, not just online agreements, but particularly in online agreements because of the way consumers actually read those agreements or not read them, as the case may be.
And particularly with arbitration, too, when you're dealing with a confidential setting like that, it kind of also prevents protection of future consumers from learning from the common law and the development of the common law.
Oh, sure. It's you're right, absolutely. The arbitration is usually just considered to be between the two of you. It's held in confidence, and oftentimes there's a term in the agreement, again, that the terms of the arbitration will be held in confidence, and there's no record for other people to see, how the arbitrators have decided.
So you've mentioned a position taken by the United States, for instance. I was wondering if there were any other international or provincial precedents or approaches that you can mention that we might be able to learn from.
Yeah, I just recently did a study for Industry Canada Office of Consumer Affairs, and we did a comparative look at this issue in relation to several jurisdictions. We looked at Canada, the United States, Australia, the UK, and the European Union. And it's interesting, The European Union approach is very different from, I guess, what I would say, although the UK is part of the European Union now, but the sort of the common law approach now that we use in Canada and the United States, where the focus in the European Union is on protecting the consumer with respect to online contracts. That's specifically what I'm talking about. The risk in common law jurisdictions like Canada and Australia, and to a somewhat lesser extent in the United States, is the risk is more on the consumer versus the vendor. And I'm not quite sure why that is, but there's a simple solution to this with respect to giving more consumer protection to the consumer, and that might be a route that the European Union has taken, and that is simply by indicating that certain terms that are patently unfair to the consumer are not enforceable. Easy thing to do. And in fact, some legislation in Canada, I believe British Columbia, has unfair written into the consumer protection legislation. Now, how it's interpreted is another matter. But certainly, a lot of companies, for example, that have these buried form selection clauses and choice of law clauses in their agreements when they sell in North America, they just don't have them in Europe. And it's not because there's a whole lot of jurisprudence that's been decided on the issue. It's just basically that they know that there's this legislation that says, well, if it's patently unfair to the consumer, it's unfair to force the consumer who lives in Germany or France to go to California to arbitrate an agreement for $50.
Yeah.
Right? That's just unfair. And so they don't even bother putting that in the agreement because they know that it's not going to be enforceable. So if you look at an agreement that Microsoft has for selling their services in the European Union, the agreement will not have that small print that we have in our agreements here in Canada because they know that they can't do anything with that. It's unenforceable.
Yeah, interestingly, when we're looking at your paper and the commentary on the EU and the Australia legislation, when we're looking at the term unfair, there's always this notion of a significant imbalance between the parties' rights and obligations.
Mm-hmm.
How does that kind of translate into the Canadian contract law context?
Well, I think you have to put it in the consumer context, right? And again, if we're to look at what happened in the European Union by having this unfair contracts legislation for consumers, it's just patently obvious in a lot of circumstances that this is going to be an unfair procedure, right? So again, to give you an illustration, if I'm in Canada, well, let me give you an example of a particular case. People study the Rudder and Microsoft case now, right, in first-year contract law.
No one forgets that.
Right.
Yeah, I just did.
Right. So there you have a situation where you have a bunch of law students who sued Microsoft because Microsoft took some payments inaccurately from their account or something. But anyway, it was a lawsuit, and they tried, I think, to have a class action. And Microsoft raised the issue that, wait a minute, you can't do this because when you sign on to Microsoft, you look and you'll see in the agreement, when you clicked I agree, you'll see in that agreement that you have said that all disputes are going to be held in the state of Washington, right? And you're going to have to come to Washington to argue, and it's going to be subject to the law of Washington State, which is, of course, where Microsoft resided. You know, is that fair to the consumer? I don't think so. But nevertheless, we don't have that unfair word, that term in the legislation, at least in Ontario, where this case arose. The Ontario court had no problem whatsoever in just saying in that particular case, look, you signed on to this, you should have read the fine print, you didn't. We don't look at whether it's fair or not. It's just simply a matter of entering into an agreement. You entered into the agreement, and by golly, you're bound by it. Mm-hmm. And there are worse cases, right? There's another case that happened a little bit later, the Rogers case, where people, I think it was signing on to Rogers cable service, or it could have been their cell phone, I'm not sure. But basically what happened is when you signed up originally for the Rogers agreement, they said that they could change the terms of the agreement at any time, right? And again, this is buried in the small print. And they did. They changed the agreement. All of a sudden, prices increased or whatever. The agreement was changed substantially. And again, people complained. And in this case, again, there was an attempt to have a class action. Court said no, because it was a binding arbitration clause. You had to go to binding arbitration in order to settle this. And you got notice of that on the website. And the court, if you read the decision, it's actually, you sort of have to laugh in spite of yourself at what the court says. You only had to go through 8 pages or something to find to find where they actually changed it. And the court said, you agreed that they could change this on the website when you initially set up the agreement. And that meant that the court said that put an onus on you to periodically go to the Rogers website to see if any changes were made. So I don't know what you're supposed to do, go through the 50 pages or so to see if any language has been changed. That seems to be what the court was saying.
That, to me, speaks to the idea that the courts aren't necessarily conscious of how we often consume things online and how we go about signing these contracts, or even reading or not reading, as the case may be, these contracts. Do you think, along with your recommendation of changing the unfair language, that perhaps courts need to be educated in these areas?
I agree. I mean, I would think judges buy stuff online. Maybe they don't. But really, in Canada, of all of the jurisdictions that we've looked at, it really is shocking that the decisions that are emanating from Canada don't look at all past what the contract says. They don't look at the fact that it's small print. They don't look at the fact that it might be unfair to consumers. They don't look at the issue of unconscionability. They don't look at the fact, like California does, that the laws where they are trying to put you into are not as strong as the laws of your home jurisdiction. None of that is considered. Now, part of that might be because it wasn't raised in the hearing in some of these cases. But I find it hard to believe that some of these issues were not brought before the courts. And even the Supreme Court of the United States, which is considered to be quite a conservative court, has said that at the very least it's incumbent upon online vendors, to at least highlight terms that might be unfair to consumers. I mean, we don't even have, they don't even go down that road in Canada. And I don't know the reason for that.
Now, just to give our listeners a little bit, what do you think that consumers in Canada can do under the current regime in order to best protect their legal rights?
It's difficult. If a box comes up where you're to hit I agree, you know what? You should read the terms before you do that. Now, what that probably means, however, is that you probably will stop buying stuff online if you were to do that. And I buy stuff online, and I confess that I hit I agree all the time, and just you're taking a risk that everything is going to work out okay, because if it doesn't, you're probably going to be bound to some arbitration agreement. If it's outside the country, it's probably going to be in the home state of the vendor, for example, in the United States. And you may as well just kiss your money goodbye, because you're not going to go through the whole process, right? Now, oftentimes that's not a problem, right? I mean, there are stats that say that every year Canadians spend something like $18 billion for online goods and services. And last holiday season, at least 60% of Canadians made an online purchase. And that's amazing. 60% of Canadians, it's more than 20 million people, made an online purchase during the holiday season.
That is, yeah.
So people are doing it. So that means most times it's okay. It works. It's when it doesn't. It's when you get a defective product, or it's and we do have consumer protection legislation that covers some of this, but it's when you do have a problem and you want to sue and you want your consumer protection legislation to apply to the transaction, you might not be able to have that because you agreed that it would not apply.
As a follow-up, you have outlined some of the types of clauses that are particularly important to look at, so arbitration clauses. I was wondering if you could outline, which kind of keywords we should be looking for when going through these contracts, if we don't have time, for instance, to read 20 pages.
Well, focus, it's particularly nefarious now, too, because, you don't even have to click I agree sometimes, because now we have browse wrap contracts, which are basically standard practice now. So, you go to the front page of a website, just pick one, Air Canada or the Bay or whatever. At the bottom of the page, you'll see probably, small, not large letters, but they're down there, terms of use, right? So you click on those terms of use, and you will see that there are all kinds of provisions there that are basically binding you to the agreement pursuant to those terms of use. So the courts have said by proceeding through the agreement and buying the product or the service, as long as those terms of use are available and clickable, and let's say you don't do it, you're still bound by them.
That's astounding.
Right. So you don't even have to click I agree anymore. So browser app contracts, as I said, are basically standard practice now. So what can consumers do? I guess, again, either before you click the I agree button, read the terms of use, or just on your first page, read the terms of use. I was giving a seminar to a group of students about a month ago on this particular issue, and I called up a couple of websites online and showed it to them. I was in the law technology class. And some of the terms of use are staggering. Now, you should look for, first of all, arbitration clause, because likelihood that's going to be there, mandatory arbitration clause. Look for choice of law clause, which law applies, and form selection, which jurisdiction you have to go to. Those are the big ones. It's also going to be possibly other things like limitation of liability and that sort of thing. Those are common as well. I remember when we called up the Bay, and just went through some of the terms, and one of the terms was that even when you think you form the agreement, when you send in your credit card information, etc., the Bay reserves the right for up to 48 hours or something to say, no, we're not going to sell you that product. So you think you have the agreement at the time when actually you really don't. You're supposed to wait 48 hours. Now, you wouldn't necessarily know that unless the Bay contacted you within 48 hours and said, sorry, we're not abiding by this price.
So it's offer and acceptance unless we say otherwise.
Unless we say otherwise. Yeah. But you'd agree to that. Right?
Yeah.
Always
So
get the last
so what you've actually accepted is that they can come back and change their mind.
Oh.
Now, I think we have time for one final question today. We were just wondering, you highlighted some recommendations going forward in your paper. If you could just elaborate on those briefly.
Yeah, I mean, one of the recommendations is basically that we possibly adopt in our domestic consumer protection legislation something like what's in place in the European Union. And again, it's very easy to do by just putting in something in relation to unfair contract terms. And you can even specify, right, what some of these are. Just specify the most common ones, like form selection, mandatory arbitration clauses. Say that those are, at least at first blush, those are unfair terms to consumers. So in those cases, if consumer legislation is amended to render those terms unfair in standard contracts, standard online consumer contracts, and again, I'm specifically referring to consumer agreements here because I think when you're dealing with business to business, it's a whole different dynamic, that if those terms are unfair, then they're not valid, and therefore they can't be enforced. The other recommendation that we've made in relation to this is that specific rules for distance contracts take into account the specific features of the medium, and that is, we should have some recognition about the way people actually use the internet and buy and sell online, and it's becoming even more difficult with mobile devices, right? You've got a phone in your hand. People do order stuff online from their phone now. I mean, it's just small screen. Of course, you're not going to hit terms of use and then try to scroll through tiny print on your phone. We've got to recognize that that's the way people are doing things now, and that's going to have an impact on on the consumer, and that those sorts of situations should at least be reflected somehow in consumer protection legislation in relation to online agreements.
I know I buy movie tickets like that nearly every week.
Right.
As a final question, I was wondering if there's any reason to believe that Canada is shifting its way of doing things, or whether of any people who are lobbying or any court cases that have come out that are kind of shifting the focus.
Sure. Yeah. One of the things I would say is that there has been some response by the provinces in some jurisdictions to some of the egregious results of consumer protection outcomes in the courts. For example, with respect to mandatory arbitration clauses and the thing that happened in, for example, the Rogers case in Ontario that we talked about a little bit earlier. There's another case that went all the way to the Supreme Court of Canada, and the Supreme Court of Canada upheld again the arbitration clause. And again, at first blush, you would think, well, what's wrong with an arbitration clause? An arbitration clause is a good thing. You don't have to spend money on lawyers and go to court, but it's being used in such a way to deny consumers their rights. That's the problem. So this has been recognized by some jurisdictions in Canada. So, for example, mandatory arbitration clauses in consumer agreements are now of no effect in some jurisdictions in Canada, notably British Columbia, Ontario, and I believe Alberta. But because we have that Supreme Court of Canada decision that says they're okay, in those provinces that haven't specifically outlawed them in their jurisdiction, they're still in effect. So here in Nova Scotia, for example, they're perfectly valid. So I guess there has been some notice by some jurisdictions in Canada that there's an issue here, and they're seeking to, at least the provinces, the legislatures are seeking to remedy some of the excesses here of the decisions of the courts.
Well, Jane, do you have any final questions for our guest?
No final questions, although I'm going to go read my iTunes agreement right after this.
You might be surprised what you see there.
Oh boy. Well, thank you very much for joining us. This was a thoroughly enjoyable interview.
You're most welcome. I enjoyed it too.